Hi, this is Brian Parker, and I'm doing another wonderful video. Perhaps not wonderful today because it's going to be a little sticky and a little perhaps boring, but I am going to cover something today that many people call me about, and I face myself, obviously, and it seems to be something that bears a lot of attention, so hopefully I'll give you some fruit today that'll help you. What we're going to do today is called how to respond to a summary disposition or summary judgment. I'm laughing because I could never imagine watching a video like this, but today I would. That would be a great thing, and I do, and I get great ideas and tips. So hopefully today you'll get great ideas and tips. This video is obviously done under the auspices of trying to educate, inform, and maybe entertain you. If there was ever a video where you weren't getting entertained, I think it is today. If you want to go watch cats playing piano or something, that's fine. But if you have a real need for this is going to be helpful. So a summary disposition or a summary judgment is one of two things. Usually it's being filed to kill your case. And we're going to talk at the end of this video about killing your case with it. But the other kind of summary motion or summary judgment is what's called an early filing. It's mostly done in federal court, but an early filing is done for one of two reasons. Unfortunately, the number one reason why someone files a summary disposition. So before I tell you that, a summary disposition or a summary judgment, as I said, towards the end you'll find out, oh, and by the way, we'll have a nice little bonus at the end of this. I believe, done right, the bonus I'm going to tell you about will help you win your summary judgment every time. Your summary judgment is not how I would describe what's happening. They're doing it to you mostly. They're trying to kill your case, or in some rare times, they're trying to figure out what the hell it is you're trying to say. Now, everything is a pleading. So if I answer a lawsuit, that's a pleading. If I sue on a lawsuit, that's a pleading. If I have affirmative defenses, those are pleadings in some sense. And you've got to support whatever your pleadings are. So the first kind of summary motion, which is always asking the court to dismiss something that you filed, is the early filings. The early filings of a summary motion, and this is more prevalent in federal court where I used to be more prevalent, but I'm finding myself doing a lot more state court these days. State court early summary dispositions, regardless of your state, are rarely done. And when they're done, I shouldn't say they're rarely done, but they're not meant to kill your case. Most states allow the early filing of a summary disposition where it is an attempt to kill your case from the other side. But even if they win, generally you have a right to amend. In federal court, if you get a motion against you for summary disposition, the rules allow, depending on how early, for you to amend your lawsuit so that summary motion no longer exists, because it's based generally on the first thing you've amended. Now, if you amend a comma or a period or a couple of words, the court's going to go, nope, we're going to hear the original summary motion. That's just not that big of a deal, big of a change. But generally, especially in federal court, you have the right to amend. And in state courts too, even if you're facing an MTD and you didn't change your lawsuit, the outcome is generally, yeah, we'll give the guy a chance to amend and we'll see what happens. So you're rarely going to, anybody that files those kind of early motions, they know they're not going to win per se. So why is it done? The number one reason why law firms file these summary motions so early is, well, think about it. What did they used to say about casinos? Those big buildings weren't built on winners. Those big law firms and big buildings and huge rents and high overhead aren't built on a lack of billing. They bill the hell out of the file, and that's a good chance for them to make $2,500, $5,000, maybe $7,500 on what's going to be a losing disposition. And here's the other thing about early dispositions. They give you who are having to change your filings now because of this motion, a chance to take a look at another attorney saying, hey Parker, you screwed up and here's why. It's almost as though they're giving you a free lesson on how to fix your pleadings that may have had some holes in them. I filed all kinds of really unique stuff, and because it's so unique and sometimes there's not enough case law or statutes to be interpreted, they'll do a little bit more research that I didn't do because there's just so much going on that I'm trying to figure out for a first time filing. And you'll see this and go, oh, they're right. Well, don't have a bad attitude about that. We don't like to lose anything, but you can go, wow, they just did the research for me by telling the court, here's where Parker screwed up. And in an early motion, I have the right to amend my complaint. I look at it as a chance to another attorney to do some research for me. So it's all about your attitude. Now, if you're someone that's not represented and it's your first time in court, it's all a real big pain. I get a lot of clients that get a summary motion against them. They call me because it becomes overwhelming. I get that. But it doesn't have to be. It's all about attitude in life. It's all about attitude. So I look at these early motions as a great chance to see where I screwed up, and the court allows me to fix my complaint. Also, a lot of the state court rules, depending on what you file upon, there's usually a laundry list of reasons why you can file a summary motion. Jurisdiction, venue, a big one is lack of clear definition of what the heck you're trying to say. So they'll say, I want a more definite statement, and this should be dismissed because he wasn't clear about what he wanted to do. Well, in that sense, there's case law and statutes that say, give the guy a chance to amend then. That's the most negative outcome. So early motions are probably filed usually in a certain situation, but they're never there because someone's trying to do a better job. I would argue, especially in federal court, those early motions are done just for billing purposes. They give you a free chance, a free lesson, free research on the other side's dime. And I generally know that attorneys that are filing those early motions where I can just see, oh, I'm going to win this, they've done it just for billing purposes. And what they do is they'll have an associate file it, then they'll throw in one or two senior associates so they can bill the thing 3 times. There you go. So why would there be a filing that benefits mostly me if it's coming against me or if it's coming against you? Again, it's just the worst that could happen if it's a person that's not represented, he's being bullied. And the 2 reasons they do that is to first overwhelm the guy that filed a answer without an attorney. By the way, you have a right to do in court without an attorney, and I've met people that do just as good a job or better than some attorneys, and I've got a great story coming up in a future video. But it's done to overwhelm you, and it will serve that purpose. And then they'll follow up with a bunch of discovery, and now you're overwhelmed. So that's one reason. The other reason is, honestly, is to set the unrepresented individual up for future filings to come in with the second kind of summary motion, and that's the killer summary motion. The killer summary motion occurs usually at the end of the litigation. In fact, when you answer a lawsuit, you immediately get a date for a pretrial. Now the court knows both sides have answered the lawsuit, or somebody's shown up for both sides. So it'll immediately set a pretrial. A pretrial is where you get together and you set the litigation dates, witness lists, exhibit lists, and then the most important thing for most people is the time amount you'll have to do discovery, where you get to go see what their case is about, they get to see what your defense is about, or your case, if you've done a counterclaim like I always do. But you will hear at the pretrial this, here's a tip. The focus of the collection attorney asking the court and this is their whole focus. When's the date for the summary motion? They want a summary motion date because they know that's the only thing that matters to them. They want to kill your case. And that's the second kind of summary motion, where it's the killer motion. And that is after discovery. So what are you going to do about that? Well, here's another tip. Courts want to get rid of cases. They want them out of their hair. Why? Because they're facing two pressures. Number one, the legislature in most states says you only have a certain amount of time to do these cases. Get them in, get them out, get them in, get them out. Secondly, cases pile up, and now the court is having to actually be at work all the time, and it overwhelms the courts, and after a while you start to see the same people in the cases. So courts generally look at motions for summary dispositions not from, hey, let's see which side won this, but an opportunity to get rid of the case. That's kind of sad, but if you're facing a summary motion and you're not responding like the best job you could do, and even then it's not going to work because the court loves summary motions as a chance to just kick them. So what do you do about that? I don't think the court is saying, I like this guy's summary motion, so it gets off my docket. They're just saying, this is an opportunity to get rid of this dumb case. They're all, two attorneys yelling and screaming. It's just a human thing. The judges don't have the opportunity to be skilled and detailed in their analysis of hundreds of cases. And the summary motion is just about on every case. That's the big gun that the lawyers have, especially on the collection side, is that summary motion, which they've written 1,000 times. So what you need to do is, in response to their summary motion when it happens, file your own summary motion, because the court is not saying, I'm only going to rule on this guy. It just wants a reason to get the hell out of this case. So there's two ways to file a summary motion in that case. When you respond to your summary motion, there's parts of most state rules that say, all right, if you're being filed against and it is clear that the filer, the guy filing the motion, has not done a good job, but your defense shows that you clearly have won this, in that same motion you can file within the court rules just a little blurb in your response saying, I think you should rule for us, and here's the rule. And most statutes in most states have the ability just to turn it around in the same motion. So you're not doing a lot of work or having to pay filing fees to do a motion against them. That's one way. Within their own motion, you can fight back, and the court rule allows you to actually ask the court, hey, while you're looking at this, go against them. So that may give you a chance to either stick around or get the case kicked, but for you. And the other one is file your own summary motion. I talked about this in a previous video where the court set the date for trial and also the date for the summary motion of my opponent on the same day. Well, what do you think is going to happen there? The court's not going to let us win, and then it has to go with a full docket, now do a trial for a couple of days. So I knew that if they set the date for the trial and the summary motion, that ain't getting to trial. So I filed my own summary motion. So now the court has to rule one way or the other. It's going to kick this case, but I think I did a really good job giving the court an opportunity to kick the case, but on my behalf. So that's one approach to get around a court that wants to kick cases, but you have to be wary of the killer motion, the final motion that occurs. And it occurs on that date where you've heard at the pretrial that, Judge, when's the summary disposition motion? That's the one when it's coming. So what do? You use your discovery. You start plowing into them and get the documents that benefit you, because generally, especially in a collection lawsuit, they got nothing. Also, they're required to turn over, and courts specifically mandate this in their scheduling order, which occurs after the pretrial. You got to turn everything over to the little guy that you're suing and show him. Take advantage of that. if you have to do a deposition, that's a tough nut if you're unrepresented, but take advantage of that. And another thing to take advantage of is collection companies don't want to bring a guy in from Citibank, the company they bought the debt from years ago, to prove all their paperwork. Nobody wants to do that. Fly a guy in from New York to Podunk, Michigan, not going to happen. So the court rules allow them to bring everything in from that person, and he's certified that everything he's talking about, has personal knowledge, and it is everything the collection debt buyer says it is. That way, he doesn't have to be forced to come in court to say that. If he just certifies it, the court rules allow, and it's usually the same court rule. It's 911 or 912 in state court, and you just put whatever the state equivalent is in front of that. And it allows a certified, notarized affirmation that all the information that normally one would have to, in open court, verify, can come in without a person. So that must occur within a reasonable time within the discovery period, or they lose the right to not bring someone in. They have to bring someone in because they can get the information to you soon enough. So I always insist upon a deposition. And that brings either problems over there, because then they're fighting with me about the deposition, and they will forget about bringing the paperwork as an equivalent, or they'll bring it too late. And then I can go to court, well, they did what they're supposed to do with trials in 3 days. How am I supposed to do discovery? So they're not allowed to not bring someone in. Remember, in many times, my name is Brian P. Parker. P is for problem. You need to be a problem maker. Anything you can do to cause them problems within the rules, you do, because they'll just give up. They got hundreds and thousands of cases. So don't be nice. Nice guys get their cases kicked and they lose, and you owe money. So don't be nice. Be rule abiding, but cause them problems. And they'll make mistakes. Collection companies hang themselves. They have the wrong documents. They don't produce in discovery. They wait too late for things. And then if you want to depose their guy, it drives them nuts. That's one way to defend against the coming killer motion. It's not called a killer motion, but that's the way I look at it. It's trying to kill your case. When you get that summary motion, what do I do with it? How do I handle it? Tear the thing up. Take it page by page with your pen and your highlighter, and first figure out exactly what this is about. Why are they saying your case or your defense should die? Usually with me, they're saying, Parker, your defense sucks. Also, the counterclaim you brought sucks. And it's never a good motion. I rarely see, because like you do the work in the initial pleadings. That will protect you down the road. That will protect you against summary motions. But find out what they're most concerned about. Here's the rule. When people file summary motions, they bring their best case forward at the very first. That's the one that's the strongest argument. The one at the end, it's called a throwaway. You just, I'll just throw this in. Sometimes it hits, but the most attention should be faced on that first argument that they're making, because that's their strongest argument. It's just, as simple as you never get more than one chance to make a first impression. They want to make the first impression with the court that your case sucks. It is personal inside that motion against you. They will make personal statements about how bad you suck or how you did something wrong. With me, even though it's Jones v. Bad Collection Company, they'll just talk about what a schmuck I am all the time. That's I see that in hearings. It's Mr. Parker, Mr. Parker, Mr. Parker. But generally, they'll talk negative about you and how you didn't do all these things. The number one thing that you can do is to think, as I always tell people, think 3 motions ahead, 3 cases ahead, 3 hearings ahead. This is the thing you need to look ahead at. So when you have a pretrial, Your preparation actually starts for a summary motion, the killer summary motion, the day you file the answer. Your answer should mirror your response to that eventual killer summary motion if you've done a good job. You can go to collectionstopper.com. Tons of my answers, you see exactly what I'm talking about. It's all about the preliminary statement. The preliminary statement is where you're telling the court before it falls asleep, because you're going to lose their attention, but right at the beginning, and there's no rule requiring you to do this or stopping you, so I do it. I want the court to know, boom, what this case is about. And every time I'm in front of that court, as I've counseled you before, keep repeating, always be closing, keep telling them, this is what this case is about. So when you're filing that summary motion response, there's the preliminary statement that you first had in your answer. You are really answering a summary motion. Be clear about this. Your answer should be your answer to the complaint should be what your response is going to be to that eventual summary motion in about 4 to 6 months. So load that sucker up like you're filing a summary motion response, because you are, and it will save your ass down the road, because you don't have to sit there for 3 days writing like sometimes I do. You've already done the work, and the court has heard the same thing again and again. Your chances of winning that motion, when you try a case, you try to say the same thing from 3 to 8 times. I keep repeating the same thing, and I've said in other videos, if you look at how to try a case video, that's a good example. If I've done a good job, as I keep saying the same thing, I've seen jurors repeat with me as I'm saying it. Well, guess what? They're going back into that jury room as favoring my case. They'll tell them, hey, what's this case about? I've repeated it. You need to keep repeating it. And that starts in your answer to the lawsuit against you. Go to collectionstopper.com, podcast plus, tons of answers as templates. I'm not telling you how to do your job or how to practice, but you can see I load that thing up. Second most important thing, maybe the first most important thing, is your affidavit. Your affidavit carries you through from day one to the summary motion you're going to be facing. And that affidavit is telling the court, first, here's what my case is about. I don't owe the debt. This is my brother stole my ID, whatever the thing is. By the way, just because you have a stolen ID, a collection company, meaning you didn't start the debt, a collection company is not going to go, well, someone stole his ID. They'll come full even harder on you, even though you present them documents and police reports that it's not your debt. That there's a mentality in the collection industry that if there's a debt, that person must owe it. So your great defense should be in your answer, because you're responding to the killer summary motion 4 to 6 months down the road if you're in state court. In federal court, it's a little bit longer. So to avoid having court against you, to shrink that docket, to avoid having this collection agency that's not going to listen to the truth trying to kill your case, do everything at the very beginning and then wash, rinse, repeat. Keep talking, always be closing. The essence of a summary motion is the person bringing the motion is saying there's no genuine issue of material fact. It's a law argument, meaning the facts don't help the person answering the lawsuit, the debtor. The law should say that she loses her case. So, another reason why the preliminary statement is important. You need to muddy the waters with your position, showing that there is so much dispute, a genuine material issue of dispute. What is material? It's in the eye of the beholder, and if the judge wants to kick your case, it better be material and obvious. So if you allege that you don't owe as much to the debt collector that's suing you, that's not material, because the liability is you probably owe it if you haven't proven that you don't. A material issue is ID theft. I have got this debt against me, it's on my credit report. Here's proof that I did not sign for this debt. I didn't pay anything on it. That's not my name. That's a material dispute. So when the motion is filed against you, a killer motion, that there is no dispute that their case should survive and he or she should lose. If you have a large, genuine material dispute over the facts, then we move on to trial. Because if there's no dispute over the facts, then the trial finder, the fact finder, has no reason to take this case. So then the court is hearing from the other side, there's no facts here to go to trial, rule against him under the law. And there's specific case-killing rules that they file these motions under if there's no genuine issue or dispute about the facts. So again, big tip, the answer is everything. You need to muddy the waters and show the dispute, because why? You are fighting the summary motion already in your answer, because it's a coming. So think about that. Do your work in your answer. If you use something like a solo suit, and it sounds like I'm crapping on them all the time but I'm just using them as a noun. If you use a service that is showing you how to answer the lawsuit, those services are good to avoid the default, but they don't say anything about why you will win down the road or why your case is strong. Why? A preliminary statement is the way to go. If you want to maybe somehow get one of those services that do the answers for you, and then you can add my stuff, God bless you. But generally people just want to file an answer and then they just want this away from them, and that's not the approach, because it's coming. If you can, invest in an attorney, or if you can't, look at my website. It's all free right now. Someone says I should monetize it, but right now it's right there. How to do everything you need to do to beat a collection lawsuit. I have videos. How to beat a collection lawsuit. How to beat UHG. How to beat Midland Credit Management. There's so much on there, either podcast or videos. Go help yourself. But you need to do the same thing twice. Once, tear up the motion, the summary motion, break it down why what they're saying is true. By the way, here's some fun tip. If you read those motions a couple of times, you'll start to see that some of the facts and law are wrong, meaning they do so many summary motions, somebody else that they're suing will show up. Well, remember I talked to you about getting personal? You tell the court, these guys are terrible. This is John Smith and I'm Sandy Jones. And look at all these facts. Your Honor, if they can't do a good job here, you can't accept anything they're saying is credible. And they're attorneys. I'm just an unrepresented guy, and I saw that. Your Honor, for that reason alone, you can't reward them for their bad job. They should know better, and courts will listen to that, by the way. If they get a chance to smack a guy they've been sick off for a couple of months, they'll do that. So tear that thing up again. You will see stuff where they are clearly wrong or using the wrong case, or the facts don't even belong to you. But you got to do the work. With that in mind, I want to talk to you real briefly about ChatGPT, which, here's my opinion on this. The best way to use ChatGPT that I find, I'll say, hey, I'm facing a summary motion under securitization. What are some good approaches? It'll break down arguments. That's good. It'll organize for you, and it'll clarify and sharpen my spear. What it won't do is properly, honestly report the law. It makes cases up. Lawyers are getting nailed right now. They're using ChatGPT as a paralegal and just signing off and filing it, and they're having to pay big sanctions, and it's really embarrassing. Don't depend on ChatGPT for case law, statutes, or even opinions. I know certain things and I'll go, hey, what is this? Knowing the answer, and I've seen it where it's wrong. So, but it does do a good job of setting out your brief when it's not making arguments based on case law and statutes for you. So it maybe is good for organizing your thoughts or introducing you. Like I've looked at, there's been times where I'm like, I didn't think of that. And I go do the work investigating what ChatGPT said, and it's good. So be very careful with ChatGPT. I have the $20 a month service just because I want to make sure I got the best chance of getting the best stuff. But even then, they'll give you case law. I remember the first time I used it, there were these cases that depressed me, excite me at the same time. There's 3 cases. I'm like, I did not know I could have used those. I could have done so much better job, and then I couldn't find the cases. That really scared and bothered me because I know the attorneys have just file a brief for me, write the whole thing for me, and they've got caught. You can go on the news and check it out. But it's all about the preliminary statement. It's all about the affidavit. I've got a video on how to write a killer affidavit. If you want, everything you do should be about filing a response to that summary motion. It's your best chance you have. Eye candy. That's the last thing I'm going to talk to you about. Make sure points that you want to make. I feel childish saying this, but if, for example, your argument is, look, they don't have an assignment showing they have a right to sue me. They don't own the debt. I will write, they don't have an assignment next to the point I'm making, and then an arrow to the thing that I want the judge to specifically key in on. And then on exhibits that back that up, I'll put pink sticky notes because I know the judge is way too busy on a Monday morning with 6 summary motions he's got to listen to. And maybe he didn't read my stuff. Who wants to do this stuff on the weekend other than me? It's Sunday. But I put sticky notes, pink, and I watch, and I can see she's looking at the pink sticky note. Well, she's going to where I want her to. Those pink sticky notes are making the argument for me. So think about eye candy. Make the judge specifically write on a thing that you want her to look at. No assignment, so I put a bill of sale up and I write, there's just no assignments, and then big question marks. Circle it, and an arrow pointing, showing the court. It's human. We're in a TikTok society, so this blue blood approach to law no longer exists in certain areas. We're in a TikTok society. We're in a Twitter X society. We want things quickly. We want links. We don't have the time to do the work, we say. So focus on that preliminary statement. Now, the number one thing that nobody is really going to tell you, but I will, on summary motions. You know I'm a big proponent of securitization theory. It's more than just a theory. I'm starting to put it into all my answers, my responses. There's no argument against it. There is their argument, but it easily falls apart. So what does that do for your case? If they are busy fighting with you about securitization in their argument, they're getting away from that main argument that I talked about, their first argument. So if you delve into securitization, you might be, check it out, creating your own genuine material dispute of facts. What's the dispute? They don't own the debt. And according to their own records, their 10K records, Citibank says Citigroup takes all receivables and securitizes them to get them off their balance sheets. Well, when you securitize, you're changing ownership. In order for Citibank to sue you again, they must have received the assignment back from the trust of your specific debt. Never going to happen. I've asked them for proof. Never. But now we've got to dispute a material issue. Do they own it? Do they not? You could win just on securitization. So that's, I know you're looking at that. That's your bonus today. When you're responding to a summary motion, look into securitization as part of your response. By the way, if it's a creditor and in some cases debt buyers, it should already be in your preliminary examination if you're a Parker disciple. If you are, you can find everything I just said on my Collection Stopper website. Go to Podcast Plus. Everything you want, including my show notes. They're on there too. So if you don't want to look at this face anymore, but you want the information, my show notes. Every podcast and YouTube, I take the time to write this stuff down, so at least I'm somewhat clearer than I normally am. But those notes that I give myself, I give to you for free on Podcast Plus. If you like this, it's kind of boring today, but I hope it's cool if you're facing one of these motions. Subscribe, please, like me, all that stuff. And I hope I've done a good job for you. And have a great day.